Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 196 of the NCDWI Guy podcast. On today's episode, we are talking about hot off the press State versus Forney, North Carolina Court of Appeals published decision. This is the second great recent case for the defense on a DWI related issue issued by the Court of Appeals in about a month. Last month we had State versus CKD come out, a great Knoll case for the defense. If you want to go back and listen to that episode, I discussed State versus CKD on episode 191. Great case for the defense when it comes to detention related issues, and arguing State versus Knoll. That was an unpublished decision. Today, State versus Forney is a published decision regarding the observation period as it relates to breath testing. Now, State versus Forney was a case that was originally tried in Buncombe County, the county where I primarily practice out of. And my good friend Tim Henderson was the one that argued this case in Buncombe County. Tim is an amazing public defender here in Buncombe County. If you want to listen to the very entertaining, hilarious Tim Henderson, go back and listen to episode 42. If you watch the episode with Tim, episode 42 on YouTube, Tim is sporting his headband, red, white, and blue headband that he wore during the COVID time frame. And so very entertaining and hilarious to listen to Tim. But this was Tim's case here in Buncombe County. And ultimately, what the court is deciding in this, again, published opinion is, does the observation period mean anything? Now, ultimately in this case, I'm going to give you kind of an overview of the case. I am going to go through the facts of the case and then kind of ultimately what leads to the court's outcome. But in terms of big picture, basically big picture of this case, between the first and second breath test, the chemical analyst in this case noticed that the defendant had gum in his mouth, ultimately asked the defendant to remove the gum prior to the second sequential breath test in the intox room, then asked the defendant to provide a second sample without initiating an observation period. So gum was in defendant's mouth before first breath test, was removed prior to the sequential sample and thrown in the garbage, and then second sample provided with no observation period renewed. So again, big picture, the court says that is a problem and the breath test should have been suppressed by the trial court. Ultimately, the case was found to not have prejudiced the defendant, and so there was no, because there was no finding of prejudice, there is no issue on that front in terms of the admission of the breath test. Now, I have kind of got my finger crossed that Mr. Forney or his appellate counsel do not choose to further appeal this case. And I don't know the ins and outs of appellate casework, but the fact that the Court of Appeals found that this did not prejudice Mr. Forney for anyone else involved, any other future defendants involved, that may have been the best things for them. Unfortunate for Mr. Forney that the court found that this breath test should have been suppressed, but ultimately found that even though it was allowed into evidence and the jury considered it, it didn't cause prejudice to the defendant and uphold his conviction. Although that didn't help Mr. Forney, this opinion. I'm hoping that this makes it less likely that this would be appealed further to the Supreme Court, because this case provides just fantastic case law for the defendant when it comes to the observation period. So we're going to get into the facts of Forney. We're going to get into the law of Forney. But before we do that, I kind of just want to take a step back and what this case ultimately comes down to. And the court doesn't get too much into this, but I think what the state so often forgets about is that the observation period is mandated by statute. It is required in each and every situation where there is a breath test requested by the charging officer / chemical analyst, really by the chemical analyst. A lot of times the charging officer is the same person, but this is a question of, is there really a reason to have this observation period? And fortunately, the court says, yes, there is a reason to do an observation period. It is important in terms of the integrity of the chemical result that an observation period occur. But I think a lot of times the state would argue, or kind of in their own mind think, this is just total, idiocy to even have the observation period. Yes, it's a safeguard that's in place, but if the observation period were ignored, it would make zero difference in terms of the breath testing outcome. Feel like that is somewhat sometimes when I've kind of had issues in the same arena as what was presented in Forney, the state has basically said, look, this wouldn't have made a difference in terms of how the test, whether or not the observation period was complied with, whether or not your client had something in his mouth. None of this makes any difference. The test was a 0.08 or greater. Let's just forget about like whether the observation period is important. And one thing that to me is, an interesting policy argument towards really holding the state's feet to the fire on the observation period is that if this observation period is meaningless, if it's not providing an additional safeguard to the defendant, if it's not helping to ensure that the breath test results that are ultimately spit out of the machine are actually accurate, then we are wasting an incredible amount of officers' time. Now, I don't know the exact figures of DWIs charged in North Carolina in 2023, but again, kind of giant ballpark figure. It is somewhere between about 30,000 and 50,000 DWI charges that were charged within the state of North Carolina in 2023. And if we want to assume that, probably 80 to 85% of those cases involve an actual chemical result, i.e., it's not a case where there was no chemical result obtained, not a case where there was a blood draw that ultimately happened, or there was a refusal, that the vast, vast majority of cases involve a breath test sample being requested and obtained. Let's just, for the sake of ease, let's say there's 40,000 cases a year where there was a breath test sample obtained and an observation period utilized in order to get that chemical result. Well, if the observation period is meaningless, if it doesn't do anything for the case, if it doesn't provide any additional safeguard in terms of the accuracy of the number presented, then we have literally just wasted 10,000 hours of officer time. 40,000 cases multiplied by 15 minutes per case is 10,000 hours of officer time that has been wasted doing something that is totally idiotic. And so really the question that the Forney court is addressing, but really it's one that anytime you have an observation period issue, it's, does this matter? Does this matter? If during the observation period, the officer steps out of the room or is on intox video or body camera video, clearly distracted from observing the defendant, you have an observation period issue. If you have a situation where your client has dip, in this case, gum, some foreign object, takes in water, whatever it might be, if there's some foreign substance that is taken in, we have an observation period issue. And the court in Forney, to their great credit, basically says the observation period is important. The requirement for that is laid out in statute. The requirement for that is laid out in the North Carolina Administrative Code. The observation period is important. So let's just kind of go through the Forney case and take a look. But this is a situation, this is a case that if you have an observation period issue, Forney is definitely going to be a case that you are going to want to reference. This is Court of Appeals number COA 23-338, originally decided January the 16th of 2024. And so in terms of the factual background of this case, the defendant was pulled over by Officer DeGrave of the Asheville Police Department. The stopping officer, who is not the chemical analyst, Officer DeGrave, does field sobriety tests. He notices other cues of impairment with regard to the defendant, but specifically and important for this opinion, the facts indicate that DeGrave's suspicion that defendant had consumed alcohol was also raised when he saw the defendant put a piece of mint gum into his mouth. So the stopping officer observes the defendant put a piece of mint gum into his mouth. He ultimately places the defendant under arrest for driving while impaired. He takes the defendant to the Buncombe County Detention Center. At the detention center, a second officer from the Biltmore Police Department, Kenneth Merritt, is called to act as the chemical analyst. And important in, again, this particular case is that Merritt noticed that the defendant had chewing gum in his mouth. He had the defendant spit out the gum and then administered a second breath test at 12:07. I'm sorry. Merritt administered a breath test at 12:05, which resulted in a 0.11 BAC reading. When Merritt then noticed the defendant had chewing gum in his mouth, he had the defendant spit out the gum and then administered a second breath test at 12:07 a.m., which again resulted in a 0.11 breath test. So basically, again, between first and second breath test, chemical analyst sees that there is something in the defendant's mouth, asks him to remove chewing gum, and then proceeds with the second sequential test. There was experts involved in this case from both sides. There was an expert from the Department of Health and Human Services that came in and testified, as well as the defense. The state called Daniel Cutler, an employee of the North Carolina Forensic Test for Alcohol branch of the Division of Public Health within the Department of Health and Human Services. The defense had a expert witness that talked about the impact that chewing gum might have on the results. The state's expert presented, according to the opinion, several studies, none of which involved the Intox ECIR2. So, basically studies that were from other breath tests some of which showed that sugar-free gum would potentially cause alcohol concentration in a defendant to decrease if somebody was chewing sugar-free gum and then blew into the breath test. Another study, again, not with Intox ECR2, showed that out of 75 chewing gums, only one brand increased a BAC. That was the Trident Splash Strawberry with Kiwi. So if you chew that gum, be careful. That's a gum that can cause elevated breath test, according to one state study. But again, none of these studies had anything to do with the Intox ECR2 device. So there was expert testimony presented by both the defense and the prosecution, and ultimately the court effectively found that because the observation period was not followed, that the result of the breath test should have been suppressed. So here we are in the analysis portion of the opinion. Defendant argues that after having defendant remove the gum from his mouth, Merritt, the chemical analyst's failure to conduct a new observation period rendered the intoximeter results inadmissible under the relevant provision of the North Carolina General Statutes and related Department of Health and Human Services rules. We agree. The court says a chemical analysis of the breath is admissible in any court if it is performed in accordance with the rules of the Department of Health and Human Services. And it's citing North Carolina General Statute 20-139.1 B1. One of the requirements under the North Carolina Administrative Code, the court went on to say, is that when administering a test using the intoximeters, a chemical analyst must, quote, ensure that observation period requirements have been met before collecting 2 breath samples for analysis. And it cites 10A North Carolina Administrative Code 41B.0322. It then talks about what the observation period is. And the observation period is defined by statute in the definitions section of 10A NCAC 41B.0101. It is definition number 6, the observation period. An observation period, according to the administrative code, means a period during which a chemical analyst observes the person or persons to be tested to determine that the person or person has not ingested alcohol or fluids, regurgitated, vomited, eaten, or smoked in the 15 minutes immediately prior to the collection of a breath specimen. The chemical analyst may observe while conducting the operational procedures in using a breath testing instrument. Dental devices or oral jewelry need not be removed. And so as the state and the defense are arguing this, the defendant at both the trial level and at the appellate level basically say the observation period in this case was not complied with because the defendant had a foreign substance in his mouth. Wasn't complied with, should have been a new observation period should have started. And I think it is important to note that the chemical analyst in this specific case, Officer Merritt, during examination did testify that he should have started a new observation period. He said that that would have been basically, I think that maybe the words that he used was best practice, but he did admit he should have started a new observation period. I don't know that that really has anything to do with the court's ultimate decision making, but the chemical analyst himself indicates, should have done a new observation period. On the state side of the argument, the state basically says the definitions and structure of the statute and the code related to observation period give a very specific list of items to look for. And so during the observation period, the state says you're supposed to look to make sure that the person being tested has not ingested alcohol or other fluids, regurgitated, so kind of spit up within the mouth potentially, vomited, actually thrown up, eaten, so put food down, or smoked. And so the state at the trial level said, chewing gum is not within this list. There's a very specific list here. Make sure that the person hasn't ingested fluids, regurgitated, vomited, eaten, or smoked during the 15 minutes, and that's it. So if they're chewing gum, then that doesn't fall under the definition of eaten. And so there was apparently, according again to the opinion, there was a conversation at the trial level about whether chewing gum is meets the definition of eating. The trial judge ultimately found that that did not meet the definition of eating, that chewing gum was not equivalent, and therefore, because chewing gum is not one of the prohibitions under the observation period specifically mentioned, that it did not violate the observation period to be chewing gum, and therefore allowed the breath test to be admitted into evidence. And the state really hit hard on this rule or this list and said, look, if there's anything outside of this list that is not mentioned, then it doesn't violate the observation period requirement. The court says, uses some statutory interpretation rules. And one of them that it points to is in attempting to ascertain the legislative intent behind a statute or rule, strict literalism should not be applied to the point of producing absurd results. And ultimately, that's what the court says the state's argument leads to, is absurd results. And here is a section of the opinion that I think is just really well reasoned, but also again, just powerful language depending on your particular case. We believe, so this is directly from the opinion of Forney. We believe the intent of both the legislature and DHHS in the provisions pertinent here is clear: to ensure that the chemical analysis of a subject's breath is accurate in measuring BAC and not tainted by the presence of substances in the mouth during testing. And in our view, to adopt the state's position that the observation period is not violated when a subject, quote, chews something during the period would lead to absurd results and have bizarre consequences, because it would mean, for example, that a subject could engage in the following activities not listed in the North Carolina Administrative Code moments before the taking of breath samples. And here's what the court lists as examples: chewing gum, presumably including nicotine gum, or tobacco, or food that is spit out before swallowed, dipping snuff, sucking on a medicated throat lozenge or hard candy, using an inhaler, and swallowing a pill. Surely, if ingesting other fluids would include ordinary tap water, it is a potential problem in ensuring an admissible chemical analysis of a breath sample. The examples just stated would likewise be problematic. So again, the state's argument that this particular item, gum, is not listed in the statute specifically, the court says that's crazy, because look at these other things. And again, I mean, if you look at the packaging on gum, I know this because I had a client many years back, probably beginning of practice, that was chewing, I think it was Big Red. We got a copy of the Big Red packaging, and there was some sort of basically functional equivalent of alcohol in the Big Red gum. But if you look at certain types of gum, that kind of chemical that chemicals or directly alcohol, but chemicals that can mimic alcohol are contained in certain types of gum. So obviously gum is one of these issues, but the court points to a number of other issues where they would not specifically violate these list of things that are laid out in the as problematic in the observation period definition section, and yet clearly could have a impact on the results themselves. One thing that the court did a good job of spelling out is, and let me see if I can find this real quick as I'm flipping through here. Here we go. Whose burden of proof is it that the observation period is met? It's the state's. As the proponent, this is from the court, as the proponent of breath test evidence in an impaired driving case, the state bears the burden of proving compliance with the observation period requirements set out in North Carolina General Statute 20-139.1, quoting State versus Roberts. So again, it's the state's burden to show that this is met. And why is all of this important? Now, I don't think that this is necessarily fundamental to the opinion of the court, but this is great dicta language from State versus Forney. And it is basically talking about why, again, do we care about the observation period? Why do we think it's important to make sure that the results of the intoximeter or whatever device is being used are actually accurate? Well, quoting the defendant's or the state's expert witness in this case, the court here in State versus Forney says, more importantly, as Cutler, who again was the DHHS expert witness for the state, more importantly, as Cutler testified, the intoximeter estimates alcohol in the blood based on a measurement of alcohol in the breath. Extremely important, because this is language that could be helpful in other cases, in Nayron Simmons type cases where you are arguing the basically arguing that the balance of the evidence does not I'm trying to think of the right verbiage here. Basically, just because somebody blows a 0.08 or greater alcohol on the intox doesn't require a conviction. Okay, so if you've got a case where you've got very limited signs of appreciable impairment, the number is what it is. This is where you're going a lot of times in arguing for the jury to ignore or put aside the actual number. More importantly, as Cutler testified, the intoximeter estimates alcohol in the blood based on a measurement of alcohol in the breath. The intoximeter estimates BAC, a ratio which in reality varies amongst different people by using a single specific ratio to standardize the testing of all subjects. Test results for breath samples taken from different persons chewing gum, even under Cutler's testimony, would likely differ from those where a subject did not have foreign substances in his or her mouth during the observation period and while giving a breath sample. This circumstance undercuts the efforts indicated by the DHHS rules to standardize chemical analysis by intoximeter and frustrates the intent of the General Assembly to automatically permit the admission of such evidence in any court. So what the court is ultimately saying is that effectively the breath testing is meant to give an estimate of a person's blood alcohol concentration. And that's what, in fact, breath testing is. It's an estimate of a person's blood alcohol concentration. Why do we care what a person's blood alcohol concentration is? Because if there is alcohol in the blood and in the bloodstream, there's alcohol in a person's brain. As the blood goes to the brain, once there is alcohol in the brain, now your central nervous system is potentially impacted. Does having alcohol on your breath impair you? It does not. Does having alcohol in your breath or in your blood impair you? It very well could. So why do we care about the alcohol in the breath? Why do we care about that? We really don't, because that doesn't show whether or not somebody is impaired. Having alcohol on your breath doesn't cause impairment. It is not correlated to impairment. What is it correlated to? The alcohol on a person's breath can provide an estimate of the person's blood alcohol concentration under Henry's law. We talked about this. I don't have the specific episode number where we were kind of talking about different attacks to the breath testing device, but one of those attacks was Henry's law and basically the correlation between breath and blood testing, with breath testing effectively giving us an estimate, I would say potentially a poor one, but an estimate of a person's blood alcohol concentration. So the court says it is important to follow the safeguards, the observation period that is required by statute and basically laid out by the Department of Health and Human Services to make sure that our estimate of blood alcohol concentration, which is breath testing, that our estimate is as accurate as possible. We already know it is simply an estimate. Therefore, we want to make sure it is an accurate estimate. And the observation periods is one of the safeguards in place to make sure that the testing is being done appropriately, that the estimate is accurate. So, again, that's kind of the major items from Forney. Again, because of the other evidence of the other cues of impairment, because of the different kind of pieces involved in this particular case with some of the signs and indicators of impairment, the standardized field sobriety test, the court ultimately found that even though the breath test should have been suppressed and it was error for the trial court to allow the jury to take that in as evidence, that the jury's receiving the breath test ticket was not prejudicial error, and therefore the conviction stands. So ultimately, again, the conviction was upheld because there was no prejudice found. But in any case where you have an observation period issue come up, Forney is an incredibly powerful source, incredibly powerful citation. It's a published case. It's got incredible power for you to use in attacking the admissibility of a breath test where the observation period was not strictly followed. Great case. Again, thanks again to the Court of Appeals. Second opinion for the defense on a DWI issue in as many months. So hopefully we just keep this streak coming. But hopefully State versus Forney will help your client. And I look forward to speaking with you again next time.